Okay, so welcome to our third or fourth guest speaker series that we have hosted by the Hubbard Free Library. And tonight we have Nathan Fried Wessler, who's from Hollowell. And introducing him will be Ken Young. And I'm just going to go through a few rules, regulations, and if you have any questions, feel free to post them in the chat. We'll definitely make sure to get to them at the end of the discussion. There will be a break in the middle for a few minutes. So feel free to take that time to think of questions. And my name is Annie. I am the current Hubbard Free Library Director. So if you have any questions about the library, feel free to ask them as well. All right, so Ken, take it away.
Thank you, Annie. Good evening, and welcome to the Hubbard series of Zoom presentations on interesting topics that is part of our annual fund support program. My name is Ken Young, as I mentioned. I'm the president of the Hubbard Board of Trustees, and the annual fund, as I mentioned, is the principal source of financial support for the Hubbard. If you'd like to add your support to the Hubbard's annual fund, you can write a check or you can donate online at hubbardfree.org, and you can click on the red and white tab in the upper right corner that says support the Hubbard, and you can make a lump sum donation. You can set up periodic donations using your credit card that occur automatically. More and more people seem to be favoring that because they don't have to remember to make contributions. It happens normally. Tonight's program, Privacy in 2020's America, is presented by Nathan Fried Wessler. Nathan Fried Wessler is a senior staff attorney with the American Civil Liberties Union's Speech, Privacy, and Technology Project based in New York. He focuses on litigation and advocacy around surveillance and privacy issues, including government searches of electronic devices, requests for sensitive data held by companies and other third parties, and use of surveillance technologies. In 2017, he argued Carpenter versus United States in the United States Supreme Court, a case that established the Fourth Amendment requires law enforcement to get a search warrant before requesting cell phone location data from a person's cellular service provider. Nate grew up in Hollowell, as Annie mentioned. He graduated from Halldale and went to nursery school with my daughter, Sarah. He's pretty sure that his Hubbard Free Library card expired in 2005. Well, curiously enough, we haven't been able to find one, but we're going to issue one that'll be good for his lifetime as soon as we're finished tonight. And he asked me to be sure to indicate that he's delighted to be back as a guest of the library. Nate, welcome. I'm looking forward to what you have to say.
Thanks very much, Annie, and thanks, Ken. And I really am thrilled to be here. It's great to see so many familiar faces. And too bad that I haven't been able to get up to Maine in a while due to the pandemic, but what a nice way to be able to connect and talk to folks. So I want to spend the next hour talking about a few threads of my work and some of the challenges that I spend my days thinking about when it comes to ensuring that our legal and constitutional protections for privacy keep up with modern technology. So I'm part of a team at the National ACLU that works on free speech and privacy issues. And as Ken said, I focus really on issues of police practices, law enforcement access to people-sensitive digital data, use of surveillance technologies, and the various privacy concerns that stem from those. So I will do my best to save a bunch of time at the end for questions, but with that, I will jump right in. Just share my screen. Okay, so the major part of my work is Fourth Amendment litigation. It is trying to get this document that was written more than 200 years ago that effectively tries to ensure that government searches, really law enforcement searches of our private places and effects are reasonable. Now, the challenge of my work and what makes it interesting and difficult is that we're taking a document that was written when searches look like this, right? Colonial British forces or early American constables entering people's homes, rifling through their parchment papers, looking in their physical carriages, and applying it to the world we, of course, live in today, which looks nothing like that in many respects, right? Where, I would much rather a police officer look through the random pieces of paper in my bedroom right now than get access to the years and years worth of emails I have on a Google server or all the other bits and pieces of my private life that are strewn across devices and digital platforms all over the place. I want to give you a little quick primer in the Fourth Amendment law that I deal with, then leading up to that Supreme Court case that I argued and that we happily won, and then talk about kind of where that leads in terms of privacy protections in the digital age under the Constitution. Talk also a little bit about some really path-breaking legislative protections that the Maine legislature and municipalities in Maine have passed in recent years, and then come up for air for questions at the end. So for years, for centuries really, the Fourth Amendment was understood to basically protect against physical incursions by the government, right? So it was clear when law enforcement came into your home, that was a search, and so a warrant would be required, and a search without a warrant was unreasonable. That principle came under stress in the early 20th century as people started using various kinds of electronic communications, particularly telephones. And there were a set of cases first in 1925 called Olmsted, and then some other cases following from that, that reasoned that the Fourth Amendment had nothing to say if police listened to your private phone conversation by clipping into the wire once it was already outside your house, because they weren't infringing on your private property. You didn't own the phone lines. Too bad for you. In 1967, in a case called Katz, the Supreme Court expanded its conception of what is protected against law enforcement access. It was a case where a suspect was using a phone booth he was a bookie placing illegal bets on some kind of sporting event, I think. And police put a listening device on the outside of the phone booth. They knew this was his normal phone booth to conduct his business. And the government's argument, they did it without a warrant. And the argument was, it's not his phone booth. And we didn't touch him, his body, or his home. We just put this listening device there. He has no Fourth Amendment constitutional interest in protecting himself against that surveillance. It got up to the Supreme Court, and the Supreme Court disagreed and introduced a concept of privacy into Fourth Amendment protection. It explains that the test now is whether police have infringed on a reasonable expectation of privacy. We expect, as a society, our phone conversations to stay private between the two parties to them. And if police find some new technological way to listen in, that's an incursion on the privacy rights that we expect under the Constitution, and police should have to get a warrant. Now that was a major change in Fourth Amendment law, and one that resulted in lots of positive changes for people's privacy rights. But as we, in a prelude to the questions we'd be thinking about in the digital age, the cases started to go off the rails in the 1970s in a pair of cases involving certain kinds of sensitive records held by companies that people have relationships with. So there's a case in 1976 about someone's bank records, account statements, canceled checks, and another in 1979 about a police request for a record of all the phone numbers a particular suspect had dialed. And in both cases, police accessed that information without a warrant. They just asked the companies for it. And the Supreme Court in both cases said, that's fine. You're out of luck, criminal defendant, person who challenged this collection of evidence without a warrant, because these aren't actually your records. You knowingly shared your canceled checks and your account details with the bank. You know they needed to know money in, money out to keep your accounts. You know when you dial on your rotary phone that you're sending these numbers to the phone company to connect your call. You've given up this information, even though, as the other side, the losing side, argued, this reveals just an incredibly private set of information about your life. Everyone you talk to, all the details of your financial situation. Nonetheless, it's not your records anymore, it's the business records of these companies. Now, that was I think a wrong decision in the 1970s, but it's become a completely untenable rule, what has come to be called the third party doctrine, the principle that once you share information or records with a so-called third party, a company, you've given up your privacy rights in them. As we now, of course, have just incredible amounts of private information stored not in our homes, not even on our own computers, but sitting in the cloud, sitting on the server of companies like Google and Facebook, our emails, our private Facebook messages. And then the incredible numbers of apps that people use on their smartphones that track medical information, menstrual cycles, relationship statuses. The one on the left, that's a smart mattress app where you put a little fixture over your mattress and it measures your heart rate and your breathing rate and your activity during the night. It can reflect not only whether you are sedentary or active in your bed, but how many people are sedentary or active in your bed, right? This is incredibly sensitive stuff we're talking about that we no longer have physical control over if it's sitting on a company's servers. And if that third party doctrine is really the rule, we're in trouble because it means police can get access to it, any government agent can get access to it without a warrant, without showing probable cause to a judge and actually narrowly constraining the scope of their search. So the case that I argued in the Supreme Court was the culmination of a years-long effort that I and my colleagues engaged in to try to get this issue, this third-party doctrine, up to the U.S. Supreme Court, to give the court an opportunity to at least step back a little and provide greater Fourth Amendment privacy protections to this incredible array of digital records. The case involves cell site location information, cell phone location data. So as I'm sure you are well aware from the little bars at the top of your cell phone that shows how good the signal is, right? Your cell phone has to be talking to a cell tower in order to connect for a call or text messages or data connections. Well, every time the phone connects to one of those cell towers to make or receive a call, send or receive a text message, or to make a data connection of any kind for an app, a weather update, watch a video, the phone company logs a record of where that phone was based on which cell tower and which directional face of that tower the phone was connected to at the time. And that happens just as a regular matter, of course, from the phone companies. They have reasons to do it for billing records and for network connectivity assessment reasons. But it means that the phone company is holding on just an incredible array of data about where you've been. And as phone companies have put up more and more cell towers, this map is, so the Carpenter case arose out of Detroit, where police obtained, without a search warrant, without showing probable cause, obtained 5 months worth of historical cell phone location data for the man that became my client, Timothy Carpenter, in an investigation. And as phone companies have put up more and more towers to handle greater bandwidth usage and greater adoption of smartphones, the locational precision of this tracking gets quite fine because cell towers are covering smaller areas. So knowing which tower you're connected to, sometimes in a rural area might not be that revealing. You know, you're in like a 15-mile square mile area. But in denser suburban or urban areas, can pinpoint people to 1, 2 blocks, and there are even much smaller cell sites now that can place someone within a few feet. So we had been working over the course of years to protect this information, among other forms of sensitive digital data, both in the courts and in legislatures. And Maine actually was the second state in the country to pass a law back in 2013, so 5 years before the US Supreme Court took this issue up, requiring a warrant for this cell phone location data when police went to the phone company to get it. Montana was the first state, and then Maine, and then a cascade of other states joined, about a dozen others in several years after that. And that actually became an important part. It was an important protection in and of itself, but it became an important part of the kind of swell of energy that led to the Supreme Court. So we ended up representing Timothy Carpenter, who was trying to argue that when police got these months worth of cell phone location records, about 13,000 individual location points without a warrant, it violated his privacy rights, notwithstanding that they didn't get it from him directly, they got it from his phone company. And the court agreed with us. The Supreme Court concluded that that in light of how deeply revealing the cell site location information is, how deep and broad and comprehensive the reach of it is, right? It just charts a picture of everywhere you've gone over all space and time during the time period that police get, and in light of how inescapable and automatic collection is, right? The court explains that you just can't be a modern human without access to a cell phone for work, for family, for emergencies. And once you have a cell phone, unless you turn it off, you can't stop the phone company from knowing your data. And so for all those reasons, the court was going to depart from, and did depart from, this old third-party doctrine. It didn't get rid of that doctrine altogether. It said there may still be some records like the bank records and the dialed telephone numbers we dealt with in the 70s that are not protected. But at least this compendium of your activities and location over time is just a different class of privacy violation, and a warrant is required. So the challenge now is to take that ruling and figure out how we can use it to expand privacy rights for other kinds of sensitive digital data. You know, it was a groundbreaking opinion in that it fundamentally changed how we understand the Fourth Amendment privacy protections in the digital age. But it wasn't an opinion that said, you know, here's the easy three-part test for figuring out what other types of digital information should be protected. Instead, it did a lot of describing what was so sensitive about cell phone location data, why it was so concerning that it was unavoidably created, and told the story of our life. The court talked about it as revealing the privacies of life and contributing to a too permeating police surveillance. But one of the fun and challenging aspects of this kind of legal work is then taking those sort of descriptive principles and figuring out how to get courts going forward to apply them to other kinds of information. So some of the other issues that I have been working on to extend that principle from Carpenter are not just historical cell phone location records, but real-time records. A couple years ago, I worked with the ACLU of Maine to file a brief in the Maine Supreme Judicial Court in a case where police without a warrant had, and in fact in violation of the Maine state statute, had tracked someone's cell phone. There are companies other than phone companies that have location data. Google is the most notorious of them. Anyone who has an Android device or who is using Google Maps and who doesn't disable their location history in their Google settings results in Google having this tremendous compendium of our location data, which potentially is available to police. Google insists on a search warrant, as it should. Automated license plate readers. These are cameras that police deploy on the back of police cars or on fixed poles and other locations around cities and on highways that snap very quick pictures of every passing license plate, timestamp it, put GPS coordinates on it, and dump it into a database, which then becomes a comprehensive location database of people's movements and locations over time. And then perhaps most chilling, and I'll talk much more about this in a minute, face recognition, face surveillance technology, which raises the specter of police departments and other government agencies networking together surveillance cameras in public spaces with face recognition technology in an attempt to identify all of us and any of us and to track where we're going over time, which we think should not be allowed at all. And I'll explain a little bit more about that later. And then there are other kinds of sensitive information held by these companies. Certainly the contents of our communications. The law is pretty well established now that the contents of our emails or our text messages can't be accessible to police without a warrant. Then there are other types of data where there just aren't court decisions yet. So information about the interior of our homes collected by so-called smart devices, Internet of Things devices, right? The smart mattress or the smart electricity meter that gives a granular accounting minute by minute sometimes of power usage. So you can infer when someone's home, how many rooms have lights on in them, which appliances are being used. With enough granularity, you can even tell which television programs a person's watching based on the differential power draw of different numbers of pixels and colors of pixels firing. And this is information, again, held by companies out there, not in our homes, and without strong legal protections, is free for the taking. And then information about the body from wearable devices, heart rate monitors and other wearable medical devices, prescription monitoring programs, state public health databases that track controlled substance prescriptions that include incredible sensitive information about our health, but also are of real interest to the DEA when it's investigating suspected prescription drug diversion, where we've been litigating across the country to require a warrant, and where the DEA says, oh, no, you told your doctor and your pharmacist about your medical condition, and they revealed your prescriptions to the secure state database, so you've given up your privacy interest in it. Again, it's the third-party doctrine, and we're trying to explain why there's similar sensitivity to those records as the location data at issue in the Carpenter case. And then stepping even one step further back, I spend a lot of my time thinking about other old rules under the Fourth Amendment that don't stand up in the digital age. And that really is the kind of core, intellectual core of the Carpenter decision, right? Explaining that we can't just mechanically extend old pre-digital age rules to new searches of digital age data. So we are currently, my colleagues and I, litigating a case in the US Court of Appeals for the First Circuit that sits in Boston, arguing that when travelers come into the US and Customs and Border Protection wants to search their cell phone or their laptop, a warrant should be required. The traditional rule for searches of luggage at the border is that there's no requirement of individualized suspicion, certainly no warrant, on the theory that the government has an interest in stopping contraband. And we argue that that just can't be the rule for our electronic devices because of the incredible amount and diversity of sensitive data in them. And there's just no comparison between how many pieces of paper you could have included in a suitcase 50 years ago and the record of emails and text messages and family photos and financial records and medical records and videos and you name what else that are on our laptops and cell phones today. Vehicle searches. So there's an exception to the warrant requirement in Fourth Amendment law that says that if police pull you over and have probable cause that there is contraband or otherwise evidence of a crime in your car, they can search it without getting a warrant on the theory that cars are mobile and they don't have time to get a warrant before you could drive away. I litigated a couple years ago a case in the Georgia Supreme Court arguing that maybe that's a fine principle for physical things in our cars, but that can't be the rule when police download data from the computer systems that drive most modern cars. Cars have, among other computer systems, systems that link to your cell phone to play music, to help with call interfaces, that can record your contacts. Cars have black boxes, similar to what airplanes have. Close to 99% of modern cars now come with these that can be good for crash diagnostics by the car company if something goes wrong, but also can reveal to the government a lot about your driving habits and where you've been and how long you've been there. We think that requires a warrant too. There's another doctrine under the Fourth Amendment that says if you abandon property, even if you otherwise would have strong privacy or property interests in it, you no longer have Fourth Amendment protection, right? If you leave your briefcase out in public and you never go back to look for it, you abandon it, police should be able to get into it without a warrant. We're challenging that principle as it applies to things like the DNA that we unavoidably shed from skin cells just slopping off us unavoidably as we go about our lives, that police have argued in cases all around the country, they should be able to collect and sequence the DNA in those skin cells without getting a warrant or any kind of court order because we have, in their view, voluntarily abandoned our DNA to the world. Of course, there's nothing voluntary about that process. Like, you can't avoid it. And we think those old Fourth Amendment rules just need to mean something else and to include greater protections given the incredible privacy invasion that can happen from sequencing your entire genome and knowing all the medical and familial details that that reveals. Okay, so I'm going to pause for a moment because I think there's an opportunity to hear again from our sponsor, and then I'll keep going. Ken.
Thank you, Nate. Very interesting, very interesting. To our audience, I hope you've enjoyed Nate's presentation so far. I have, certainly. I noticed there are a couple of lawyers in the group, and I'm a recovered lawyer as well. It's very interesting to hear the language, to think about the process that Nate's going through, to admire the fact that he argued a case before the United States Supreme Court. It's just fascinating, fascinating. I wanted also to talk a little bit about the situation the library is in at this point. Even with the restrictions due to the COVID-19 pandemic, the Hubbard continues to serve the community and surrounding areas After we closed in March, we started with curbside pickup in June, which people responded to very positively. And now we're offering what we call ahead in-person services, where you can call the library and make an appointment to come down for a 45-minute slot. The reason we're doing that is because under the CDC guidelines, there are restrictions on how many people can be in the library at the same time. But increasingly, people from Hollowell and other communities who rely on the Hubbard are taking advantage both initially of curbside and now of in-person services at the library. Our staff, Anne-Marie Krumhout, who's hosting this presentation, this Zoom presentation, excuse me, is our library director. Doreen Judge is a member of her staff. Stacy Linkle is another member. You'll know that Stacy does the children's hour, the book reading process. And Kate Malloy is the friendly voice who answers the phone and most times and gets you squared away in terms of where the books are, what you need to get one, where do you put the books you brought back, and so on. They do a really outstanding job of assuring that the Hubbard continues to be the vital community asset that the founders, General Hubbard and Eliza Clark Lowell, who financed the 1893 and 1897 expansions of the library building, respectively. Those people, plus the contributors and other supporters right up today, are supporting the Hubbard because they understand its value to them and to the community and want to have it continued. In a very early, just a quick aside, in a very early conversation several years ago with the City Council about the city's role in supporting the library, one supporter came in and addressed the City Council. We were there at budget time and said, imagine how hard it would be to establish a library today compared to the commitment that people made to a library in Hollowell beginning in 1880. I was fascinated by that because in the context of the time, you said it in particular in 2017, I think, it was extremely relevant in terms of where you could go to get information that was accessible to everybody, that was, while it might be biased in its opinion, you could pick and choose. You weren't locked into a particular source. So Nate's presentation about how people guard their privacy and are able to guard their privacy, which essentially is the way in which they think about themselves and their lives and their families and their role in society, is really, really, really important. And personally, I appreciate the work you're doing, Nate, and I want you to keep it up. Okay. I think we're ready to go again. Take it away, Nate.
All right. Thank you, Ken. Okay, so let me share my screen again. Okay, so I talked about one piece of the work that I spend a lot of time thinking about, all the kinds of data held by companies. I spend another significant amount of my time thinking about various kinds of surveillance technologies. So these are technologies that government and corporations use themselves to gather information about us or to track us in various ways. And the one that I want to talk about in our remaining minutes before we break for questions is what I think is to me, the single most fundamentally scary threat to our privacy and autonomy and security, face recognition technology, something that I've spent increasing amounts of time working on in the last few years. I'll explain what I mean by this in just a moment, but face recognition technology is really scary and really dangerous, I think, because it's both dangerous when it doesn't work and dangerous when it does work. And by that, I mean, oh, sorry, this is my 4-year-old. You want to come join? Oh, okay, good night. That was Layla. Thanks, Layla. So face recognition technology, when we talk about face recognition technology, what I mean is machine learning algorithms, right? So this is a computer program that when it's first written, knows nothing, but it's then trained by technicians, computer engineers, feeding in huge numbers of pairs or sets of photos, different photos of the same person. So that over time, the idea is the face recognition program learns to be able to figure out what are the attributes and measurements of a face that let it take two photos, totally different photos of the same person, and determine that they are the same person. This technology that's been in development for decades, but has really kind of turned a corner in its purported effectiveness and accuracy in the last several years, and has started to be adopted by huge numbers of law enforcement agencies and companies around the country to identify people from static photos. You take a photo of someone and feed it into a matching database, right? So you start by training the algorithm, and then you set it up with a database now of photos associated with people's names, and then you feed in a new photo of an unknown person. And the point of the program is to instantaneously, effectively search through all those now saved photos, saved face prints really, and try to match them with a new photo and tell you who it is. So this technology sounds very effective when you talk to police departments and the companies that make it, who tout its precision, its accuracy. But what I mean by talking about it being dangerous when it fails, dangerous when it doesn't work, is that like any computer system, it cannot work 100% of the time because of lots of factors, right? You're going to have photos that you feed in that were taken in bad light, that are grainy, at a bad angle. You're just going to have the computer system think it knows how to match photos, but the measurements aren't actually leading to a correct match. So there are always errors. It turns out that there aren't just errors with face recognition technology, but there are markedly worse false positive and false negative rates when it is used to try to identify people of color, darker skinned people, as well as women and younger people. And so this is a technology that has been established by numerous studies, including a kind of gold standard study by the federal government, the National Institute of Standards and Technology, by independent researchers. There's a researcher at MIT, Joy Buolamwini, who's done incredible work on showing that the face recognition systems that were built by some of the largest computer companies in the country have significantly higher false identification rates, failure rates, when trying to identify people of color. ACLU has run its own tests that have confirmed the same thing. This was a test that we ran, some colleagues ran on a face recognition system that Amazon was marketing to law enforcement, really aggressively marketing to law enforcement, until they eventually, under pressure, agreed to pause their sale to law enforcement last year. Again, really significant false positive rates. And this matters in the real world, right? We know that the criminal enforcement system, the policing system in this country, already grossly disproportionately targets communities of color and people of color for all kinds of uses of force, of arrest, of detention, prosecution, conviction. When you add a flawed, racially biased, flawed face recognition system to it, it is no surprise that it results in false arrests of Black people in particular. This is a man named Robert Williams. He's an ACLU client. You may have seen coverage about a year ago, about 6 months ago or so in the New York Times and elsewhere. He lives just outside of Detroit. That's his family in the lower left. He was came home from work one day to his suburban house to see some Detroit City police officers there waiting for him. They arrested him, handcuffed him on his lawn in front of his daughters and his wife, dragged him downtown to the police station. He had no idea what he was in for. Finally, he was taken after about 30 or so hours in detention overnight with no explanation, taken to an interrogation room where the officer, he kept asking, "I don't understand, officer, why am I here?" They slap down a photo in front of him and say, "You're going to tell us that wasn't you?" And it's a purported face recognition match. Someone had robbed a store in Detroit about a year previous to when they actually arrested him. Nobody had been able to identify the suspected robber. Someone who walked into a watch store, Shinola watch store, and just pocketed several watches and walked out. So what they had was security camera footage from inside the store. They sent it to the police. The Detroit police sent a still image from a frame of that security camera to the Michigan State Police, who ran it through their statewide face recognition system. that tries to match photos against the state driver's license photo database. And it came back, the system came back with what it said was a match to Mr. Williams's photo. In fact, he was 30 miles away from that store that day. He was driving home from work. Had police done any confirmatory work, they could have seen that he had a social media post at that exact time, a video of himself singing along to his favorite song as he drove home in the car. So it was sloppy policing, but sloppy policing based on a fundamentally racist technology that gave them what they thought must be an incontrovertible proof that this is the guy, and they picked him up and really, really disturbed his life. So it's a dangerous technology when it doesn't work, but also a dangerous technology when it works. This is the way that sentiment was expressed by Mr. Williams's criminal defense attorney, who was able to very quickly get the charges dropped against him when she finally got some documents from the government that revealed what their basis for their case was and how flimsy it was. Right, when you add a racist and broken technology to a racist and broken criminal legal system, you get racist and broken outcomes. Even if you add a perfect technology to a broken and racist legal system, you only automate that system's flaws and render it a more efficient tool of oppression. So even in some hypothetical world that we are not getting too fast, if we had face recognition technology that actually worked with equal accuracy on white faces and faces of people of color, that would be no answer, because it raises the prospect still of us walking into essentially a surveillance society. Already, many cities across this country have large numbers of networked surveillance cameras. This is just an example. Detroit, which has deployed both its own city-owned cameras, and it has an incentive system for private businesses to deploy, to give the city access to their own security cameras. So these are the locations just of the private business cameras, not the city's owned ones. And the city of Detroit has bought a face recognition system that it says it can plug into this live networked array of video cameras, surveillance cameras around the city, that purports to be able to identify and track anybody based on their face as they move from kind of coverage area to coverage area of cameras around town. They haven't turned on this live system yet, but they've bought the capacity. Chicago has similarly, there was a test of similar technology in Orlando a few years ago. And if these cities are allowed to turn this on, it's really a menace, I think, to all of us, because it's just such a fundamentally new power. It would so eliminate the ability of us to do what we just unconsciously assume we can do every day, right? Sure, we know that we might be recognized by friends, neighbors, the postal worker, if we're out and about, but none of us expects every single piece of our movement to be centrally tracked and logged by a government agency as we go about town. Never before in history has anybody had the power to just instantaneously, with the press of a button, say, upload Nate's face, let's see all the places Nate was over the last 2 months. That's just a step way too far. Now, luckily, this is a technology that already is seeing significant pushback in local communities around the country. So the ACLU, working with local community groups in a number of cities around the country, including in Portland, as many of you may have seen in the news last year, passed local bans on government use of this technology. Some of them are styled as bans, some of them as moratoria, until such time as there's both proof of accuracy and sufficient protections against abuse. But in addition to Portland, your cities from Boston and Springfield, Massachusetts, to San Diego and San Francisco, just a couple of weeks ago, New Orleans, Jackson, Mississippi, the entire state of Vermont now ban government use of this technology in recognition of its twin dangers. So I just say, before I stop for questions, just one more note about two pending bills in Maine that my colleagues at the ACLU Maine wanted to make sure I mentioned. One is that in the new legislative session, there's a bill that would ban most government uses of face recognition technology statewide. So if and when there's an opportunity to weigh in on that, I would encourage all of you to contact your local elected officials. And then second, there's a bill that was up in the last legislative session and it has just been reintroduced by Representative Warren, Hollowell's very own, that would address a problem that I have faced over and over in advocacy on the set of issues, which really frustrates the ability to get more protections, which is excessive government secrecy. So, one problem with a lot of these technologies is, of course, that they are privacy invasive, and without proper checks, they can really be used to throw open the most intimate parts of our lives without any protection. But it's hard to even figure out what the government is doing and what the protection should be, because many of these technologies operate surreptitiously by design. And there's no way to know if you see, say, what looks like just a CCTV camera somewhere, whether it's hooked up to a face recognition system. No way to know whether the government made a request to your cell phone provider for your cell phone location history. No way to know whether your comprehensive license plate based location information has been obtained, unless the government is compelled somehow to tell you. And Maine, it turns out, is, while it is a leader on privacy regulation in a lot of ways, it has the singularly worst police transparency law in the country when it comes to use of these kinds of technologies. There's a state statute that requires that if you make a public records request under Maine's Freedom of Information Law for information about surveillance technologies where the police agency thinks they are entitled to withhold some of that information under exemptions to the right to know law, this law mandates that they have to tell you not, yeah, we have some records, we use the technology, but we're not going to give you all our records. Instead, they're mandated to say, we can neither confirm nor deny whether we do or do not have any records on this topic, which makes it virtually impossible for privacy advocates, for lawmakers, for defense attorneys, for government advocates, for the press to know at a basic level what police agencies are spending our taxpayer dollars on and what kind of privacy invasive technologies they're using. So the Representative Warren, and she it was co-sponsored in the last session by Senator Bellows, who now, of course, is the new Secretary of State. The bill has been reintroduced, and I think it's a really important update. No other state in the country has this law. Every other state is much more pro-transparency when it comes to these technologies. And so I really hope that that the statute is passed in this session. Okay, so let me stop there. I can talk about these things all day long, but I won't, so that we can have at least a few minutes for questions. So let me pause.
So we have the first question is, how close are we to what's happening in China with tracking and rating citizen behavior?
Yeah, so we are technologically in the same place. Exactly the same capabilities that exist and are used in China exist in the United States. We are not yet in a lot of regards quite in as bad a place, but that's not to say we're not in a bad place in some ways. So, for example, the Chinese government has been deploying face recognition technology in all the most nightmarish ways, including expressly to track members of the Uyghur Muslim minority. There have been a couple of recent reports, not only of about the Chinese government's use of face recognition technology to track known political dissidents who are members of the Uyghur minority, but major private technology companies in China are now marketing to the government face recognition technology that they claim can identify people's ethnicity and then pervasively track and record locations, activities, and movements of Chinese Muslims. That capability at a technical level, I mean, part of it is junk science, because the diversity of phenotype among people, even inside ethnic groups, is tremendous. But to the extent it works, all that same technology exists in the U.S. It's not being used pervasively in that way, but we have certainly seen law enforcement agencies using these kinds of technologies in really oppressive ways. So, for example, in about a decade or so ago, the Associated Press ran a series of stories about the New York Police Department, NYPD's, what I call its demographics unit, which is really its Muslim surveillance unit, which was revealed to have engaged in just tremendously abusive surveillance activities against the New York City Muslim community, including using automated license plate readers to identify every single attendee who had driven to mosque services, religious services at mosques, with no conceivable tie to any level of suspicion, but instead just to get a handle on who was attending services. So I think these are not hypotheticals and something we really need to be vigilant about, and that's why strong legal protections are really important.
All right. And the next question is your thoughts on Maine Fusion program and other state police programs designed to fight terrorism by monitoring social media, etc.
Yeah, so in the years after September 11, 2001, of course, huge amounts of money were poured into purported counterterrorism programs. Very little of that money that went towards surveillance of this kind was effective, just for one, and a lot of it, I think, was tremendously abusive and dangerous. I think there are a couple things that are concerning about these kinds of efforts to sort of automate the tracking of social media. One is that it's often done by algorithms, right? The same kinds of, same idea as the face recognition algorithms, machine learning tools that are supposed to learn over time, but that are very bad at understanding nuance, sarcasm, hyperbole, jokes, etc. So you end up with lots of people being flagged for completely innocuous activity, and it's the needle in a haystack problem, right? There is these systems that were set up to counter the threat of foreign-based terrorism, right? It's not a numerically big threat in this country, right? The 9/11 was a tragedy, but there is a greater statistical risk of dying from your television falling on you in the United States than there is of dying from an act of terrorism initiated abroad, right? And so there's just virtually no evidence to be found. So these systems end up trying to generate leads based on what they see, which means lots of innocent people get ensnared in law enforcement investigations for absolutely no reason. So it's both a waste of money and can be a tremendous incursion on people's privacy and can really upend people's lives.
All right. So we have Frank O'Hara says, Charlotte Warren has another meeting tonight. She regrets that she can't participate. So, and I think we have one more question. I'll say again, if anyone has any questions, feel free to post them in the chat. This one is from James. When President Trump was taken off Twitter, it was as if he no longer existed. Can you think of a First Amendment argument that Twitter cannot refuse his messages about government?
So great question, and obviously one of a very timely concern. So no, I mean, I think Twitter is a private company, and the First Amendment, like the rest of the Bill of Rights, applies to the government. So there would be a First Amendment problem if a government agency, let's say if former President Trump, that's a delightful phrase, if the government today, if he was still on Twitter and the Biden administration said, Twitter, we are ordering you to deplatform him, ordering you to shut him down, that would be government action, and that would obviously be an issue under the First Amendment. But I don't think there's any real solid way to construct a First Amendment argument about what a private company does to enforce its own terms of service. But I think there are real important policy questions about when these companies should be able to exercise a tremendous power to eliminate people's ability to speak in what has become the public forum, right? The place that we all interact. And so, the companies have to draw a line somewhere. I think they probably drew the right line in kicking Trump off of Twitter at a moment of real peril for our democratic structure and process. But it also makes me really uneasy to think that these companies have the power to decide who gets to speak and who doesn't. And there are lots of dissonant voices and unpopular speech that you can imagine being really unpopular that we want to be part of our political discourse, even if it makes us uncomfortable at a personal level. So I think it's a really tough issue.
Right, and so Frank O'Hara has a follow-up question. It says, what about right-wing terrorists? We know there are multiple cells in Maine. We know they communicate through the dark web. Shouldn't someone be monitoring them?
I mean, so yes, I mean, law enforcement should absolutely be investigating right-wing, white nationalist extremists. And I think, you know, part of the lesson of what happened in Washington, D.C. on January 6th is that not enough attention was being paid. But I think part of the lesson was that there was plenty of awareness in parts of law enforcement agencies, but they weren't taking it seriously. I think part of that is a function of racism and not taking seriously threats by white right-wing extremists, while we saw, you know, incredible juxtapositions to the huge police responses to Black Lives Matter protests over the summer. So I think part of the answer is there's already a lot of information out there, and you know, law enforcement agents should be following leads, right? They should, you know, if somebody has posted something publicly on social media that I can see, there's no reason a police officer can't also see it, right? If it's just out on the web. Now, when we start talking about the so-called dark web, you know, there are really good reasons why people should have access to secure communications, right? So I do all my texting with lots of people in my life on a free app called Signal, which is end-to-end encrypted, and nobody, unless they have my phone or my friend's phone on the other end, nobody trying to get at it in the middle, who, you know, taps into the phone lines, can understand what the messages are. You know, I'm a lawyer. I represent people in controversial cases. I have really good reasons to be concerned about the security of my communication. So, you know, there are proposals that we've seen multiple times in the past, and I'm sure we're going to be seeing now, to force companies to build backdoors, so-called backdoors, into those encrypted communication systems. And I think that's really dangerous, because I think it will redound to the detriment of people who, as a society, we really think need to have protected communications. At the same time, yes, there are real hard questions about how we can find and enforce laws against people who do pose fundamental threats. It's a hard balance.
All right, and another comment we have is, I've talked with Hollowell business owners who want security cameras on at night to catch vandals. One even said he planned to pay for the police department to have a monitor to watch them. Are the problems you are raising about facial recognition and mass data gathering also pertinent to this desire of our local businesses?
Yeah, so I think, you know, I think there's a difference between a business that has some security cameras and they have a relatively short retention period, right? So maybe they keep their footage for 5 days so that if there's a vandalism incident, they can roll back the footage and try to figure it out. You know, I think businesses have an interest in protecting their property, and there are some reasonable things that I think they should be able to do that. You know, a business hooking up a face recognition system to its camera so that it automatically identifies everybody who walks by that stretch of sidewalk or everyone who comes in, that I think is troubling. A business that is working with police to feed police live access to footage, I think is really troubling. And certainly if police were to hook it up to a face recognition system, I think that raises really serious privacy concerns. So there's a spectrum. I think on some of these issues, there's a different privacy calculus when it's scattered individual businesses versus a unified government surveillance system. And there are differences between kind of levels of surveillance technology that are stitched together to gather more and more information. The more you stitch together, the more of a picture of someone's life someone's going to end up with.
All right, and this kind of touches on the same question and comment. It says, other countries use surveillance cameras. I just saw that in the UK, the CCTV system has about 1 camera per every 10 to 13 people. This might or might not include traffic cameras. Can you comment if you haven't already touched on the question?
Yeah, so yeah, the UK and London in particular is notorious for its deployment of network surveillance cameras that are all set into a central place and where police can easily toggle between frames and basically seamlessly track people. A lot of places in China have the same capability, and there are cities in the United States that are getting close to that capability. I think even without something like face recognition technology or object tracking technology that automates the tracking, that's really troubling. But I think the fundamentally new threat comes when these artificial intelligence systems are plugged in to these kinds of camera networks that I've talked about with face recognition technology, because that then one way to think about the problem of that is an efficiency issue, right? It no longer do you need an officer sitting there watching the frames looking for something. You have a computer doing it instantaneously and in an all-seeing way. And that's the way in which these computer machine learning technologies really change the game in privacy, because suddenly situations where even with the cameras, none of us really thought we were actually being watched by eyes on us all the time. Now, in fact, we are having our movements logged automatically and then available for playback on demand.
All right, and I know, oh, we just got one more question. It says, this might seem to be a far out tech question, but China claims it has quantum communication technology, which will prevent any kind of information intrusion. Will this not prevent law enforcement patching into any data communication systems?
So I can't speak to, I don't know anything about China's claims of quantum technology, but I mean, there certainly is a kind of arms race dynamic between privacy protective technology and government attempts to crack into it. And so, every time a new version of the iPhone is released, for example, right, iPhones have encryption technology, like it is encrypted by default, right? That's the password doesn't just lock your screen, but it actually secures the data inside, so that without the password, it just looks like a whole bunch of random letters and numbers mixed together. Every time Apple releases a new model of the iPhone, private contractors that work on government contracts start scrambling to figure out a way to bypass the newest security system for the iPhone. And so, there's a little bit of a cat and mouse game where, people try to protect their communications, and governments try sometimes for legitimate reasons, often I think for overreaching reasons, try to get access. That's part of why I think technological privacy solutions aren't enough by themselves, right? Having strong technological encryption for our communications is great, and sometimes it'll work and sometimes it won't. Having a strong requirement that law enforcement get a warrant, or a ban on local police for using face recognition technology is going to be a different kind of durable protection that doesn't put it in our individual hands to have to master technology enough to protect ourselves, but actually put some guardrails on at a policy level.
Well, so I know there was one comment from a while ago. It says, there's so much more to touch on, and would you be willing to come back?
Always happy to talk about these things.
All right, I don't see any more new questions. So I will be posting the donation link one more time in the chat if anyone's interested in making a contribution this evening. Let's see, give you another minute for any more questions. Ken, do you have anything to say?
I just wanted to thank Nate for doing this. It's fascinating, and certainly would be happy to have him back. We'll invite him sometime later in the year, perhaps once COVID is over, knock on wood and cross your fingers. He can come up, bring his family, see his mom and dad, and come to the library in person. That would be really great. We have a system in the library now, Nate, you may remember, but we had bookcases in the front of the library that kind of sat there for years and years and years. And because of a great idea and implementation by one of our trustees, Larry Morissette, those are now movable so that we can move them back. And at our kickoff last year in November, we had 100 people in the library. watching a presentation by Earl Shuttleworth that we did live. So that's something to look forward to. Maybe you could get your expenses paid if we invite you up.
Sounds great.
Okay,
I'd love to.
good. Thanks very much.
All right, it was a delight to talk to all of you and so nice to see so many familiar faces. Take care.
Okay.